Hello, everyone. This is Tom Fox back with another episode on the Hughes, Hubbard and Reed FCPA and Anti-Bribery Alert for 2024. Today, I'm thrilled to have with me Jiaxing Hao, who's going to talk to us about the Multilateral Bank, Chapter 4. So, Jiaxing, first of all, welcome to the podcast.
Thanks, Tom. Thanks for having me.
So, I'm always intrigued because the firm always has a section on the Multilateral Development Bank. And I wanted to first ask you, why is this always in the alert? And more importantly, how can studying these enforcement actions help the anti-bribery, anti-corruption professional who may be working in either a U.S. corporation or other corporation?
Should I start with giving a brief introduction of what the multilateral bank sanction is about? Okay, MDBs like World Bank and Inter-American Development Banks are organizations that fund projects in developing countries, ranging from infrastructure to healthcare to energy. And to ensure the integrity of these projects, they have sanction systems in place to address corruption, fraud, and other type of misconduct. And in the past 2 decades, the MDBs have really been key players in the fight against corruption. And one of the most impactful sanctions they impose is debarment. And this essentially bars companies or individuals from participating in MDB-funded projects for a set period of time, or sometimes can even be a permanent sanction. So for firms operating in sectors heavily rely on the MDB funding, this can effectively shut them out of the key markets.
So what are some of the key trends you saw from 2024 in this area?
Yeah, so we saw 3 major key developments. And the first major trend we've observed is this, we can call it like a renewed focus of the World Bank and the IDB on more complex corruption cases. Historically, fraud has dominated the sanction systems. Things like misrepresentation of qualification or big rigging. And because the relatively lower standards of proof for fraud cases, we just judging by number, there are still more fraud cases, but we have seen a renewed focus on prosecuting the corruption cases. In 2024, both the World Bank and the IDB had made a clear effort to tackle corruption more directly, which is consistent with their original intent of the sanctions regimes. And I think it's also worth noting that the World Bank and the IDB are the only 2 institutions among the 5 major MDBs to successfully sanction a company or individual for corruption this year.
So what are some of the key lessons that you would talk to a client about, or a potential client, or might use just in how you counsel people in this area?
Yeah, that's a good question. I think for starters, sometimes we see companies don't pay enough attention to MDB compliance because they think, oh, we already have a anti-corruption system kind of meet the standard of FCPA. But I would say that there are like a lot of similarities. For example, the use of third parties and then broad definition of payments will count as things of value. And there are also some striking differences. For example, the FCPA is mostly focused on just bribery. And then the MDBs, they are sanctionable practice, cover not only bribery, but also fraud, coercion, and then other misconduct. So if a company in the MDB scheme field is only focusing on bribery, it's gonna have some serious red flags in their bidding compliance and just to make sure their documents and records are completely accurate when they submit documents to MDBs. Yeah.
Can I take just a minute, because I was really intrigued by that section of the alert, which is entitled "The Thing of Value is Broadly Defined." And there were 2 points in there that I'm not sure anti-corruption practitioners in the corporate world think about. And then the first one was, internships and employment contracts, but I was really intrigued by the third one, which reads offers to employ additional personnel to assist the project implementation unit with public relation efforts. And I saw this in 2007 in Brazil, where they would literally hire phantom employees. And that was used to create a pot of money to pay a bribe. So I wondered if you might use one or both of those to maybe expand on why anything of value is broader and why compliance professionals need to think about things other than bags of cash.
Just by looking at a limited number of the cases this MDB has published, we can see that they're really consider anything of value, like literally anything of value, to fit in the definition of corruption. And this, together with their relatively lower standard of proof, which is more likely than not, and their heavy reliance on all sorts of, because there's no evidence rule, they can rely on anything they find relevant. All those factors together made it relatively easy for them to prove cases that involve any sort of exchange of benefits for power. And that, I think, makes it very important for compliance professionals to pay particular attention to this area.
As Mike DeBernardis and I have talked about areas more traditionally defined as corporate or applicable to U.S. corporations under the FCPA, when you are counseling your clients that are working in the MDB world, how do you tell a compliance professional, you've got to look at literally how many people are being paid under this contract and are they actually working? How do you educate a compliance professional down to a very granular level? Is it through collaboration with other corporate functions? I mean, that to me seems to be a very difficult thing for a compliance professional to be able to do.
Yes, I think I'll use the example of a case we worked as the monitor of one of the largest group, like one of the top engineering companies in the world that was sanctioned by the World Bank a couple of years ago. And it's really rely on the system. First, they start with risk assessment. You really need to know where the high risk areas are and then apply it to your business. And then design a system that's fit right into your risk profile. And then robust training to make sure everyone is aware of the type of risk that they may not notice before, but it's really there. And then rely on a transparent reporting system and then very supporting tone at the top, and also reporting system to encourage people to say something when they notice something. In short, relying on the right people, the compliance professional, legal professional, to do the right thing, and educating the frontline employees like sales functions to know the risk and the report whenever necessary, and then a backline like investigations, audit to make sure our system is functioning as designed.
In the report, under the section entitled Recent Sanctions for Corrupt Practices, literally the first sentence reads, and I'm going to quote it, a significant percentage of MDB sanctions concern fraudulent practices, particularly misstatements made by bidders in bid documents, end quote. Now, this is not something we see typically in the FCPA world. Could you talk a little bit about that dependent clause, misstatements made by bidders in bid documents, and why it's so important that compliance be involved to get that part of the process?
Yes, of course. I think this is actually a very distinct area in the MDBs world because their fraud case technically require an intent. This intent, the threshold to approve intent is extremely low. So in practice, basically, as long as you submitted something that is not true or not accurate or made even an honest mistake, that is enough for the bank to establish fraud. Like intent, like real intent, whether you did it on purpose or recklessly, does not really matter. In practice, we have seen form asks the company to disclose past sanctions. The company has already been released decades ago, and it missed a note, missed a check mark, and that is enough to be considered as a fraud. Is it really helpful to achieving the bank's goal? Sometimes it's questionable, but I think it helps to demonstrate at least the bank's seriousness towards this issue, because what we just discussed is like a minor group of fraud, and what they are really trying to address is to intentionally, fabricate experience or changing the names of employees to make it or more professional. It's like higher degrees. I think it's just to have a same approach towards all the misrepresentations, make it easier for them to achieve the overall goal of making sure that all the records submitted by bidders are accurate and complete. Yeah.
So I think I'd like to end by asking you something you talked about in your opening remarks, and that's the burden of proof. I think you used the term more likely than not. That is very different than, obviously, a criminal burden of proof. I come from the civil side of the law, where I'm comfortable with the preponderance of the evidence, but it sounds like to me more likely than not is even a lower level in preponderance of the evidence. Could you say a few words about how that level or burden of proof really is very different, and it's frankly as low a standard as I've ever heard?
Yes, and I would say that is true. Just because of the low standard of proof requirement, it makes it possible for the investigators to consider all the relevant facts they can gather. It can be intels, can be whistleblowing alerts, can be the documents they gather from government audits. It can really be anything. And the banks also have the power to kind of politely ask companies under investigation to cooperate with further investigations. And that's another major source they can get documents that will help them to establish the case. And that's another challenge that companies that in the MDB field have to just unfortunately have to work with.
Well, Jiaxing, unfortunately, we are near the end of our time for this episode. But before we leave, I wanted to ask you if our listeners wanted any more information on the Hughes Hubbard FCPA and Anti-Bribery 2024 alert, or to find out more about the firm, what might be the best place for them to go?
Our alert, along with another very useful, we call it MDB primer, which more detail summarizes the MDB's procedures and investigations. MDB procedures of each bank, and is both available on our website, which is hugheshubbard.com.
Well, Jiaxing, I wanted to thank you again for taking the time to visit with me, and I hope we can continue this conversation.
Thank you, Tom.